Good evening, this is John Milburn for Laws 13010, Evidence and Proof. We're into week 9 of term 3, 2018, into 2019 now. Those of you watching as a recorded session and watching live, in fact, if you'd please go to the Evidence Act Queensland 1977 and consider section 92. Some comments about the admissibility of documentary hearsay evidence in civil cases. Now, when you look at section 92, you'll see that the heading indicates that it's about the admissibility of documentary evidence as to facts in issue. So bear in mind that only those things that are relevant to the case can be admitted as evidence through documents. And there's a further hint. The phrase in the first paragraph would be admissible if the matter was oral evidence is highly relevant as well. And you'll see that there's reference there to proceedings not being a criminal proceeding. So just in the first few lines, we see that there are some statements which provide some parameters as to the admissibility of documents in civil cases. So, as always, any evidence that is admissible must be relevant to the facts. And the test there is tending to establish a fact that would be admissible as evidence if certain circumstances. So when we're talking about the admissibility of documentary evidence, we must first consider the threshold question: would this evidence be admissible if it was given in oral form? If the answer is no, then it won't be admissible or purport to be admissible in terms of oral evidence. Subject to the exceptions, there's always exceptions, and we'll deal with that in subsection 2. But looking at subsection 1, the requirement is for the document to contain a statement that tends to establish the fact if it was admissible if the maker had personal knowledge and is called as a witness, or the document forms part of a record relating to an undertaking contained or prepared by people who had or reasonably supposed to have personal knowledge of the matters dealt with in that information. So you'll see that there are some general rules about the admissibility of the documentary evidence. One of the key issues there is that the person must be called to give evidence as a witness in the proceedings, even though the relevant part is contained within the document. But there are exceptions. Subsection 2 says the maker of the statement or the person who supplied the information because to be called as a witness is not required where one of 6 circumstances apply. The maker is dead, unfit, out of the state, cannot reasonably, with due diligence, be found or identified. If it's reasonably supposed that the supplier would not have any recollection of the matter, no party to the proceedings requires the maker to be called to give evidence by way of cross-examination, or there'd be undue delay or expense by calling the maker or supplier of the witness document. So do have a look at the exceptions, and the key when reading these sections is to try and put it into a practical context and think to yourself, how would this apply if I was on my feet and I'm faced with having to argue the toss about the admissibility or otherwise of documentary evidence? So in essence, what do we take from section 92? Well, the first is that it relates to evidence in civil cases, that it permits the admission of evidence in documentary form in 2 types of hearsay, in both cases by a person with personal knowledge. I say hearsay because documentary evidence by its very nature is hearsay. Section 92(1)(a) contains statements which are, if you like, first-hand hearsay. That is, statements whose maker had personal knowledge of the contents. Section 92(1)(b) deals with statements that were recorded in the course of an undertaking based on information supplied by a person who had personal knowledge. So if you like, that's second-hand hearsay, potentially. Now, the categories are not mutually exclusive. For example, a manager of a hotel makes a report in an incident book about something that occurs. That maker may have both personal knowledge of the content and the information contained is now in the course of the undertaking. So 1A and 1B can be satisfied at the same time, but all you need to do is to satisfy one of those two. Now, I mentioned that the evidence must have been or would have been admissible if given in direct oral form. In other words, the statement in a document will not automatically, magically become admissible if it was inadmissible opinion evidence, or it was evidence that was subject to a privilege or second-hand hearsay per se. So just bear that general rider in mind. Also, you'll note that the legislation talks about, in Part B, information in the course of that undertaking. So what do we mean by the undertaking? Again, no surprise here, we'd refer to the Schedule 3 of the Evidence Act. That contains the definition, and the definition of undertaking is extensive. And courts will interpret that widely. So there's a case in your text of Kenny against the nominal defendant. 2007 QCA 185, a personal injuries litigation matter. A trial judge accepted evidence in the form of an eyewitness statement from a 13-year-old girl. That was recorded in a police officer's notebook. The girl had been the supplier of the information, but she was excused from personal appearance because she was overseas at the date of trial. But nevertheless, as the supplier of the information, which went into the notebook of the police, which was therefore something created in the course of the undertaking, then it was admissible. So can you see the flow of logic there? But generally speaking, the caller that you must call to give evidence, the maker or the supplier as the witness. That's the ostensible requirement for the maker or the supplier to be there to give evidence. But as indicated, the subsection 2 provides for 6 separate circumstances where the maker or the witness need not be called. And in those circumstances, if you can fit within the exception, the document will be admissible as proof as to its contents, that is an exception to the hearsay rule, even though the person is not there to give the oral evidence to support the veracity of the facts which are contained in the document. Now, if you're confused as to why I keep talking about hearsay evidence, I need you to understand that I'm taking the view that documentary evidence by its very nature is hearsay. It's hearsay because it's not provided by a person who can give direct oral evidence. It's evidence of what somebody else said at a previous time when they were not under oath, as they would be in the course of giving direct oral evidence. I hope that makes sense. So even if you have someone who is called to give evidence in the witness box as the maker or supplier, they will give direct oral evidence. But once you have the content of the document inserted into evidence, then you're inserting effectively hearsay material. And so there's so much hearsay material that is lawfully admitted into court practice, and this is just another example. Remember, of course, that other general rules apply. So the court may accept the evidence may accept the document into evidence, but the weight which it gives to that evidence may vary. And indeed, when considering, say, the proportionality test in Briganshaw, the evidence must generally be quite strong, depending on the severity and the importance of the document or the information that you're intending to prove. I know I'm moving fairly quickly, but are there any questions about that? Do you get the gist of what I'm saying? We're all good? All right. Remember, of course, that Section 92 deals with that which is not a criminal proceeding, and courts define criminal proceeding narrowly. Have a look at the case of Chief Executive Officer of Customs against Labrador Liquor Wholesale. It's a 2003 High Court decision, 216 CLR 161. The High Court held that Section 2 doesn't apply where a customs officer sought a criminal penalty against a company for evasion of import duty on tobacco goods. Now, Section 93, if you like, is the counterpart. And Section 93 is the section that deals with the admissibility of documentary evidence as to facts in issue in criminal cases. So Section 93 applies only for criminal cases. In criminal proceedings where direct oral evidence of a fact would be admissible, so similar again, as was the case for civil, any statement contained in the document tending to establish that fact shall be admissible if A, the document is or forms part of a record relating to any trade or business, and then so on, and so it's an and, not an or, and the person who supplied the information is dead, unfit, or out of the state, not reasonably practical to secure that person's attendance with reasonable diligence, cannot be found, etc. So you can see some critical differences, and it's almost like a spot the difference between the sections game, and because at first glance they seem similar, but then you notice these differences, and they can be quite important differences. So I'm going to ask, this is just to get you thinking, can anyone tell me if they can identify any specific differences between the effect of sections 92 and 93 in relation to the admission of documentary hearsay evidence in civil versus criminal cases? Please feel free to use your chat facility or unmute the microphone. And I'll give you a hint, I'm looking for 6 distinct differences.
You mean 92 subsection 2?
No, section 92 versus 93 generally. Thanks, Michael. If you're watching this as a recorded session, I expect that you're working hard during this period. Those attending live are. All right, do we have any takers yet as to any differences between sections 92 and 93? Okay, we've got the first one coming through now. Thank you, Michael Fuller. In criminal matters, it refers to trade or business as opposed to what, Michael? So in criminal matters 93, it does talk about trade or business, whereas in 92, it talks about something else. It talks about an undertaking, doesn't it? So it's different. It's much more broad. Yes, Michael?
I was just going to say you're too quick for me.
Sorry. You had the answer. It was on the tip of your tongue. Thank you.
Almost.
All right. Simon says, or and, or for non-criminal and for criminal.
For 92.1a, it's got the maker of the statement had personal knowledge, dealt with the matters, or document is or forms part of a recording relating to, whereas 92, they need to have forms part of a recording relating to, and the person who supplied the information has to be dead, out of state, can't be identified, and so forth.
So it's different. I mean, in my view, 93 has no equivalent of 92(1)(a). I say that because there's no provision that allows for evidence of a statement if the maker has personal knowledge of the content, regardless of whether or not it forms part of a record. So 93 only applies for what might be termed record statements. So well done, Simon. Well done, Michael. I like those issues. And as identified, Section 93 applies to a narrower category than 92, as Michael quite rightly pointed out, limited only to that part of a trade or business, not an undertaking, which is much broader. Now, Michael Fuller says, criminal does not necessarily have to be personal knowledge. Okay. Yes. Anything else? Thank you, Michael. Any other thoughts? Simon, have you got something?
Oops, sorry, that's speaker on. Yeah, I was going to say, what we go 92.3, the courts may act on hearsay evidence for deciding the purpose on his evidence for the purpose of deciding any of the matters mentioned in subsection 2A, B, C, D, or F. Mm-hmm. Whereas in the criminal, it doesn't say that they can use hearsay evidence for deciding.
Yep, good. Thank you very much. So, and there's no equivalent in 93 of the final two grounds for admitting a record in the absence of the supplier of the information that exists under 92. That is, those in which the parties do not wish to cross-examine the supplier, or where it would cause undue delay or expense to call the maker. So thank you, Simon, for that. Another one is there's no equivalent of section 92 subsection 3 in 93. Another one, there's no equivalent of section 92 subsection 4 in section 93. And the final one that I've got is that under section 93, there is no need to call the maker or supplier of the document to give evidence for it to be admissible as evidence of the facts contained within it. Excellent work. All right. So thank you for going through that exercise and identifying those differences. One thing that we did talk about was the difference between this very broad term undertaking as used in section 92 compared with the limited interpretation of trade or business as it appears in 93 in criminal proceedings. It's obviously much narrower than undertaking, and section 93(2) attempts to provide some indication as to what it means. Police records are not admissible under section 93 as they are under section 92. That is in the absence of the party. Now, let's go on to look at a very important provision, the next provision, section 93 capital A. Statements made before proceedings by a child or person with an impairment of the mind. The effect of section 93A in criminal trials is this, that where a person is a victim, most notably in sexual offences, it allows for the packaging of their evidence in conjunction with section 21A that we dealt with last week regarding special witnesses and closed-circuit CCTV footage, special screens, and pre-recording of the evidence. So when you think of 93A, also think of section 21A. The fact is that when you look at section 21A, in fact, you need to consider all of Division 4, all of Division 4A and 4B of the Evidence Act And when you look at the Act itself, that covers a considerable portion, pages 22 to 49 inclusive, of the Queensland Evidence Act. Sorry, the Queensland Evidence Act, 1977. Division 4 deals with the evidence of special witnesses. Section 21A is included in that. Division 4A deals with the evidence of affected children and comprises 21AA to 21AX. And Division 4B deals with recordings, which is 21AY to 21AZC. But pay particular attention to 21A, special witnesses, and Section 21AD, Section 21AF, and 21AG, 21AK, which is the pre-record, 21AU, which is the exclusion of public, so that it's a closed hearing, and 21AZC, which prohibits the publishing of a record about that particular evidence. So it's all victim focused. So bear in mind the very broad definition of what is a document, and that's why we're talking about these issues within the context of documentary evidence. Do look carefully at Section 21A, the evidence of special witnesses. And a special witness means a child under 16 or a person who, in the court's opinion, would be, as a result of impairment, likely to be disadvantaged as a witness, suffer severe emotional trauma, be intimidated or disadvantaged if required to give evidence within the usual rules of practice of a court. And it's quite a lengthy section, but I will get you to read that in some detail. Now let's go back to 93A. So Section 93A, subsection 1, lays down 4 basic conditions that must be satisfied before statements covered by Section 93A will be admissible. So what are those 4 basic conditions? Number 1 is the maker of the statement was, or at least at the time of making it, either a child or a person with a special impairment of the mind. That's number 1. Number 2, the maker of the statement had personal knowledge as to its contents. Number 3, the child or intellectually impaired person is available to give evidence in the proceedings. And number 4, the statement in question is in a document. A decision of RVBBQ 2009 196 Australian Criminal Law Reports 175. It's in your text, and the Queensland Court of Appeal held that more than one statement by the same complainant in relation to the same matter can be admitted under Section 93A. Now again, when it comes to the practicalities of dealing with Section 93A, you need to consider that whole suite of sections around Section 21. Section 21AW requires the trial judge to direct the jury that evidence in a statement admitted under 93A must not be regarded as carrying any more or less weight simply because it's admitted in that form rather than in the usual oral evidence form. Now that's usually the way in which it's considered from the perspective of protecting the witness and the victim, if you like. But if you're defence, then one of the key sections to consider is the ability to object on the basis of the overriding discretion of a court to deny or exclude any evidence if satisfied that it would be unfair to the accused to admit it. So Section 130 of the Evidence Act Queensland is one of those catch-all sections that you fall back on if you're looking desperately for some argument as to why it would be unfair for certain evidence to be admitted as opposed to being rejected. Now, let's go on to the next statement, or next section, Section 93B, which deals with the admissibility of representations in prescribed criminal proceedings if a person is unavailable. So what we're really now talking about is hearsay evidence for statements in prescribed proceedings when the maker has since died or is mentally or physically incapable. So what are the preconditions for allowing this form of hearsay evidence into criminal proceedings? Well, the person must have made a representation about an asserted fact and be unavailable, obviously, but by being dead or mentally or physically incapable to give that evidence. The hearsay rule does not apply to such evidence given by the person who saw, heard, or otherwise perceived the representation if it was made shortly when or shortly after the asserted fact happened, or was made in circumstances that made it highly probable the representation is reliable, or at the time it was made, it was against the interests of the person making it. So have a look at that section, section 93B.
John?
All right. Yes, Marcus.
Just a quick question on that note. So obviously, it's a district court trial. If I was the maker of that statement and I was to give evidence thereof, I'd be there before the judge and the jury, and the jury would hear my evidence in person. Now, if it was to be admitted because of subsection 93B, because say I was sick of unsound mind, how would that evidence be heard by the jury for them to consider and make inferences from? So say my evidence was crucial. How does that work?
And this is where, and that's a really good question. Thank you for that. This is where it ties in with the sort of general concept of documentary evidence. Because if the person is not available to give it in oral form, then the only other conceivable way for it to get in is if it's in documentary form. And if we consider the definition of what is a document under the Evidence Act, it's very broad. It's not just a piece of paper. It can be a signed statement or a recording or a video or something else. So generally speaking, it would fall within that category of something else, whatever that might be. So it can't be second-hand hearsay, generally speaking, but the person who had made this representation and is now unavailable through death or mental or physical incapacity must have created some sort of document, and it's that documentary evidence that you purport to introduce as evidence as to the facts under section 93B. Does that make sense, Marcus?
Yeah, so for example, say I was a bank teller and I was giving evidence of an armed robbery, and I had positive identification of the defendant. I gave a statement to the police, a couple of hours thereafter. I picked it from a photo board. There was secondary evidence of, say DNA at the scene, or evidence from a search warrant. Now, I suffered extreme PTSD, say, from that incident, and my doctor said I was unable to give evidence at the trial. So obviously, my evidence would be fairly critical. How does my evidence? How is it submitted?
Yes, probably through a police officer. So, for example, if or by consent. So, if, for example, the identification process was recorded using audio-visual recording at the police station in the presence of a police officer, then it would be that recording. Or it may be that a statement was prepared and signed.
Yep.
So, a jury would actually see that recording, or they'd hear and see the statement. So Michael Fuller got it. Yep, the jury would receive a copy of that statement, or at least there'd be reference to it as part of the material.
Yeah, okay, thank you.
Thank you. I really like that you're thinking about the practical aspect of these things, which is very important. Okay, so bear in mind that this only applies in relation to criminal law proceedings. So just remember, of course, to read some of these introductory comments and statements at the start of a section Otherwise, it would be very embarrassing if you start talking about 93B in the context of a civil law trial, for example. And have a look at subsection 2, the 3 exceptions there where the hearsay rule does not apply in these circumstances. So 93 is relevant where there's a representation of an asserted fact, which covers first-hand hearsay to some degree. 93B subsection A, which deals with statements made when or shortly after an asserted fact, that appears to cover res gestae statements. R-E-S-G-E-S-T-A-E, res gestae. Have you read about that in your reading? You've come across res gestae? Good. All right, so you'll see there that one of the tests is whether it is unlikely the representation is a fabrication. So a good case there is the Crown against Crump. It's 2004 QCA 176. So Crump was charged with the murder of his de facto spouse. The spouse's body was found. The Crown said that he had dumped the body suitably weighed down in a lagoon in an area of state forests. A witness, K, gave evidence of an occasion when the deceased had called at her home one morning, complaining that Crump had beaten her the night before. And the Court of Appeal held that this statement should not have been admitted because although it was made shortly after the events to which they refer, it was not made in circumstances making it unlikely that it was a fabrication, since Kay could not testify as to having seen any bruising on the deceased to back up her story. So these sections need to be read critically, and if you're for defence, you need to challenge the admissibility of this evidence, potentially for a number of reasons. And Crump shows us that one of the very good reasons is to ensure that you test carefully whether it is in circumstances make it unlikely it was a fabrication. Section 93C, the next section that we want to talk about, provides for the provision of a warning to a jury regarding hearsay evidence. And it requires the trial judge to warn the jury that hearsay evidence may be unreliable, inform the jury of matters that might cause the hearsay evidence to be unreliable, warn the jury of the need for caution in deciding whether to accept this hearsay evidence, and give weight to it. So bear in mind this whole thing about some piece of evidence may be admissible, but it's an entirely different thing as to whether the jury should give any weight to it. So when it comes to hearsay evidence, make sure that there's issues of considering the weight. Now the next section is 95. If you're following through, have a look at 95, which deals with the issue of the admissibility of statements in documents or things produced by process or device. It deals with computer records and talks about statements contained in documents produced by a computer, obviously as a result of human programming, but produced by a computer. Section 95, subsection 2, contains the conditions under which the computer-generated hearsay evidence will be admissible. And you'll see that there are 4 of them. The document containing the statement was produced by a computer when the computer was regularly used to store and process information, that the information was of the kind contained in the statement throughout the period the computer was operating properly, of course, and the information reproduces or is derived from information supplied to the computer in the ordinary course of the activities. So when you're looking to challenge any evidence that's computer-based, don't just meekly accept it, but rather consider subsection 3, particularly, of that section 95. But section 95 has some potentially pretty broad application. Have a look at a case of Carolyn against Cohen. This is a district court decision, 2011, QDC 183, the defendant was charged with driving with demerit point suspension. The prosecutor introduced computer records prepared by the Traffic Department or Transport Department, purported to do so pursuant to Section 95, and it was introduced by the prosecutor in order to prove that a person received correspondence from the department. That is, correspondence giving the defendant a right to choose between suspension or a good behaviour bond, and the court accepted that evidence and that material into evidence, even though it was all autonomously prepared as a result of programming. The next section, Section 95A, deals with DNA evidentiary certificates. DNA evidence sounds like it's direct evidence, but of course it is hearsay evidence, and it's also circumstantial evidence. And if we just go back to Section 94, I forgot to mention Section 94, which deals with the issue of credibility of the maker or the supplier. So, admissibility of evidence concerning credibility of a person responsible for the statement should be considered as well. And have a look at subsections 1A and 1B in that regard. Now, Section 96 is also relevant, dealing with inferences concerning admissibility. So when deciding whether a statement is admissible by virtue of the part, the court may draw any reasonable inference from the form or the contents of the document in which the statement is contained. And then look at sections 98, dealing with rejection of evidence. This is another handy defence section in that you can argue generally that the court may, at its discretion, reject any statement or representation, notwithstanding the requirements of the part is satisfied, if for any reason it appears to be inexpedient in the interests of justice that the statement should be admitted. That's a bit like Section 130 in terms of a go-to section which provides a very broad statement enforcing the court's discretion to reject evidence if, in broad terms, it's unfair on the defence. So Section 98, particularly important for defence from a defence perspective. Now, have a look at Section 99. We talked about a statement, and where in proceedings there is a jury and a statement in a document is admitted into evidence, and it appears to the court that if the jury were to have the document with them during deliberations, they might give the statement undue weight. The court may direct that the document be withheld from the jury during their deliberations. So even though the jury may get to see a document, now a document might be a photograph, for example, if the court is of the view that, for want of a better term, and I'm exaggerating here, the jury become obsessed with the gory pictures portrayed in the photographs, which are documentary evidence, it would be appropriate for defence to say, on application, those photographs should be taken back from the jury and not taken with them into the jury room, because the existence of the photographs on the table around which the jury are deliberating might overwhelm their thought process. They're just words that I would suggest might be used.
John, what?
Yes, Michael?
It's a statement in a document. It says here, where in a proceeding there is a jury and a statement in a document is admitted. So
yes.
One part of the statement rather than the whole.
You're absolutely correct, and it does talk about and a statement in a document. So you're right, and that they give the statement undue weight. The court may direct that document be withheld. I would suggest it means the entire document, whatever that might be. So if a statement in a document is admitted, then the entire document would be withheld in those circumstances. No, well picked up, Michael. That's good. Section 100 is an interesting provision that deals with corroboration. So for the purpose of any rule or law or practice requiring evidence to be corroborated, a statement rendered admissible by evidence shall not be treated as corroboration of evidence given by the maker of the statement. Now, in a very broad manner, that might mean this, that someone gets into the witness box and gives direct evidence. They can't corroborate their own evidence by saying, well, I prepared a document along those lines. Now, here's where we get into a grey area, because police refer to their own notebooks regularly, and you might think that's a form of self-corroboration. It's not really. It's admitted on the basis that it's used to refresh their memory, and there's a good reason for that to occur. But corroboration generally, whether it's self-corroboration or somebody else, should not of itself render a statement admissible. Section 101 deals with previous statements of a witness. Now, witness statements, if proved to be evidence of facts stated, where in any proceedings, let's see if I can get it up on the screen, where in any proceedings a previous statement made by a person called is proved for the purpose of rebutting a suggestion that the person's evidence has been fabricated, that statement shall be admissible as evidence of any facts stated therein, of which direct oral evidence by that person would be admitted. So that's, in practical terms, that's a fairly important section. And then section 102 deals with this whole issue of what weight, to what extent can we give weight to the evidence that's contained in statutory or documentary form. And that's the important provision, the distinction between it being admitted and it being accepted as truthful. So consider section 102 as another good go-to section for defence. And of course, I've already mentioned the overriding discretion in section 130. Bear in mind that only relates to criminal proceedings. And if you like, section 130 deals with what we call the Christie discretion to exclude evidence. Other than that, look at section 84 and then even back 83 that deals with entries in books of accounts, and section 83 provides for a definition of book of account. So section 83 provides a little highlight of a trap in that you might think that all the definitions within the Evidence Act are contained in Schedule 3. Section 83 is an exception to that general rule in that it contains a definition for that particular part. So that's a flying overview of the documentary evidence regime in Queensland. In the Commonwealth counterpart, have a look at section 59. It sets out the general hearsay rule, and it provides that there's a ban on the admission of previous representations if it can be reasonably supposed that the person making it intended to assert a particular fact to prove the existence of the fact. So 59 represents the hearsay rule, and in the Commonwealth jurisdiction, evidence of a previous representation by a person is not admissible to prove the existence of a fact, but there are many exceptions. And have a look at the specific exceptions to the hearsay rule within the Commonwealth legislation, and you'll see there that it's 60, 64, 66, 60, 63, 64, then 65, 66, 66A, and so on, right through to expert opinion evidence, sections 110 and 111. Now, in the Act itself, it provides some excellent examples dealing with issues to do with hearsay. I'm going to run through them with you now, but I'd urge you to have this handy whenever you're dealing with any issue to do with hearsay in the Commonwealth regime. It's in the Act, so you'll have it with you in any examination context, I'm sure. Look at the three examples. Number one, see if you can follow these. So D is the defendant in a sexual assault trial. W, which witness, made a statement to police that X told W that X saw D leave the nightclub with the victim before the sexual assault is alleged to have occurred. You with me so far? So unless an exception to the hearsay rule applies, evidence of what X told W cannot be given at the trial. That's pretty basic, isn't it? So the witness W cannot say in trial, well, X told me this about what they saw to do with the victim and the defendant. So that's clearly not admissible. That's pretty straightforward hearsay. Example number 1. Example number 2. P told W that the handbrake on W's car did not work. Unless an exception to the hearsay rule applies, evidence of that statement cannot be given by P or W or anybody else to prove that the handbrake was defective. Number 3, W bought a video cassette recorder, wrote down the serial number on a document. Unless an exception to the hearsay rule applies, the document is inadmissible to prove that a video cassette recorder later found in D's possession was the video cassette recorder bought by W. Now, they all sound pretty tough, these rules, but that's the nature of the hearsay evidence rule. If you're looking for some further material to argue around this issue of hearsay, have a look at the Australian Law Reform Commission, and it gave some clear statements about what should be retained as exclusively the exclusionary rule for hearsay evidence, and provided some justification for it. So we're talking now about hearsay, and we're talking about why it shouldn't be allowed in court proceedings. So I'm going to ask you to put your thinking caps on again. And we'll just have a break for a moment so you can think about a number of reasons why, in general terms, we should not allow hearsay evidence to be introduced into a trial. Okay, see how you go. When you're ready, fire away. Why don't we allow hearsay evidence? You're at home, recorded session. Please work hard now. Okay, we're getting some coming through already. Michael Fuller says reliability. Yes. Michael Dickinson, repeating of facts not witnessed could mean 100 people say something they never saw. Yes. Because, and we tend to say, oh, well, it must be true. 100 people told me that. Nobody saw it, but everybody heard it from somebody else. Sarah says, because it produces the opportunity for unverifiable evidence to be added that may disadvantage parties of a trial. Thank you. Robert, yes, says unable to cross-examine the original statement maker. So therefore, how can we test it? These are really good examples. At the risk of cutting somebody off who's just about to add to it, out-of-court statements are not usually on oath. Usually, they're not. There is the absence of testing through cross-examination, which is what Robert identified. The evidence, which is hearsay evidence, may simply not be the best evidence. There are dangers of inaccuracy in repetition. That which was reported by A to B, then to C, may have changed during the course of repetition. There is a risk of fabrication. It's easy for people to take a critical shot, a statement, if they don't believe they're going to be tested. To admit hearsay evidence can add to the time and cost of litigation. As Michael properly identified, does it really help us if we have 100 people come along to court to give this same hearsay evidence. And another is to admit hearsay evidence might unfairly catch the opposing party by surprise. So have a look at section 60 of the Commonwealth Act. It deals with the Hearsay Rule, and it doesn't apply to a previous representation that is relevant for a purpose other than proof of the asserted fact. So bear in mind that when the objection to hearsay is to object to the admission of the evidence if it purports to prove something, a material fact that is the subject of the hearsay. Can anyone tell me the famous case that deals with the admission of evidence of hearsay statements, and it was done on the basis that the evidence was not proving that that which was said was true per se?
Was it?
Oh, Nicole's onto it, yes. And sorry, it was Marcus?
Was it DPP and Subramaniam or something similar?
Yes, you both got it, Subramaniam. So the Subramaniam case is really important. It's Subramanian against the public prosecutor, 1956 1 WLR 965. So have a look at section 60 of the Evidence Act Commonwealth, and note that subsection 2 was inserted as a response to the decision of the High Court in Lee against the Queen, 1998 195 CLR 594. Section 61 deals with the exception to the Hearsay Rule dependent on competency. Note the restriction on first-hand hearsay, restriction to first-hand hearsay. That's if we're looking at the exceptions, and that's section 62. Section 63 deals with civil proceedings, and section 63 of the Commonwealth Act follows broadly what was in section 92 of the Queensland Act that we looked at carefully tonight. And have a look at section 63, which again deals with civil proceedings in circumstances where the maker is not available. So the Hearsay Rule does not apply to evidence of representation given by a person who saw or heard or otherwise perceived something. Have a look at section 63 in that regard. Section 64 deals with first-hand hearsay in civil proceedings where the maker of the statement is available. Now, if the matter is criminal proceedings and the maker is unavailable, have a look at 65, which allows for the general provision and then the exception. Now I'm moving quickly, but I'll get you to read these in some detail. Then look at 66. Again, that deals with criminal proceedings where the statement is available. Notice provision 67 and 68, which deals with objections to tender of hearsay evidence in criminal proceedings if the maker is available. Now, in relation to second-hand hearsay, there are many exceptions, and have a look at section 69. The exception there relates to business records, but also note sections 70 through to 75, which provide for exceptions in relation to second-hand hearsay to do with other things such as documents in writing in certain circumstances, interlocutory proceedings. One of the best ways to look at this, and I think I've highlighted this previously, and those of you that are familiar with the Evidence Act Commonwealth will know all about this. At the beginning of that entire part, or that chapter, there is the excellent flowchart. So go to chapter 3, dealing with the admissibility of evidence. On page 35 of the Evidence Act 1995, you'll see what I trust is now the familiar flowchart. And that is directly from the Evidence Act Commonwealth. So the flowchart there provides a diagram and it goes through a series of questions, starting with the most basic question, is the evidence relevant? If it is, then we go on to consider the next question. If it isn't relevant, then the evidence is not admissible. So go through that process. It's really good. It applies strictly only for the Commonwealth, but the logic applies just as readily for the state material.
Sorry, John, where was that?
Yes. So it's in the Evidence Act Commonwealth, and you'll find that on page 35, and it's the second page in for Chapter 3. And Chapter 3 deals with the admissibility of evidence.
Got it, thanks.
All right, good. Okay. So what we've been dealing with tonight really is a lot to do with hearsay evidence. Hearsay is important, so try to understand what it means. In general terms, hearsay is a statement offered in testimony by, let's say, A, regarding something that B told to A, something that B heard or saw or smelt or touched or experienced, and then told A about it. So it's A giving evidence in court. Well, that's hearsay. We should really call B. That's the basic rule of hearsay. So what it means is that the evidence in court of a witness is normally confined to their account of what they perceived with one of their senses. And it also should be restricted to statements of fact. Not everything that appears to be hearsay is inadmissible as hearsay. Think Subramaniam, and the test there is, in making this statement about what somebody else said, is the witness's intention to prove that what that other person said was true? And if the answer to that is yes, then it's generally inadmissible hearsay. In Subramaniam's case, it was quite different, because Subramaniam was saying, look, these people that have got me, that held me captive, they told me they were going to kill me. The court admitted that evidence, not because he was trying to prove that they would in fact kill him, but it was evidence as to what effect that had on his state of mind, what he perceived as a result of that. It's a subtle difference, but it's important. Okay, so when you're looking at the state of mind, says Marcus, that's it. So when you're looking at the Commonwealth legislation, start at section 59, that is the general exclusion of hearsay evidence rule. Then note the many exceptions. Work your way through the flowchart and ask yourself, is this evidence, which appears to be hearsay evidence, actually hearsay evidence, or is it original evidence as it was in Subramaniam's case? Then think about some of the exceptions, such as implied hearsay. And I know you've been very patient, and I'll finish soon, but I'll just get you to listen carefully to these couple of examples. So, implied hearsay, what does that mean? A man telephones his wife at home. During a conversation, he hears a door opening in the background. He hears his wife say, "Oh, hello, Peter." A few seconds later, the line goes dead. The man rushes home. His wife is murdered. Now, the statement of the wife is only implied hearsay because she did not directly say, "Peter has just entered the house." But you can imply that from what had been said. And hearsay by conduct, I think Manchester Brewery against Coombs. All right, so what we'll do is we'll pick up next week dealing with issues to do with statements as to circumstantial evidence, statements of mind and intention. Are there any in state of mind? Pollitt, yes, that's an important case. So we'll be talking around Pollitt and those sorts of issues next week. Any questions before we sign off for this evening? All good? Okay. Thank you very much for your patience, and we'll see you this time next week. All the best. Bye then.